Okay, welcome back to Shooting It Straight. I'm going to be doing something different today. It's something that I haven't done on this channel, and I really have never had any intentions of doing it, but today it's going to be, and just for this video, it's going to be of a political nature. Generally, I stay away from politics, particularly on this channel, but it does deal with firearms and the Second Amendment. Here in my state, I was made aware of a proposal made by state legislators, and it was a minor gun control bill that's been proposed, and I don't like it. So I decided to write two of my senators, state Senate Majority Leader and the state senator that represents my district or my area. So I've drafted a copy of a letter that I intend to send to both of them, and I just wanted to read it on this video as just another backup means of documentation. All right. So I'd like to read that to you. I have my computer here. It's on my computer. I'll read it to you from the screen off of there, and give me some feedback. Tell me what you think. And this is probably the only time I'll do any type of politics on this channel, but like I said, it does relate to the Second Amendment. Okay. All right, here we go. And it's addressed to those senators. And it starts off the normal way. Dearest senators, please allow me to give some input regarding a recently proposed bill that I strongly oppose. I'm not an important person. I'm just an average citizen, so I'll understand if my input is minimalized. I am a lifelong South Carolina resident with no history of criminal activity. I proudly served 25 and a half years as a full-time certified senior supervisor and instructor in law enforcement. I have no political affiliation with either party, Democrat nor Republican, and I keep my religious views to myself. However, I do vehemently support the United States Constitution and our natural rights that are protected by it. And I feel that this legislative proposal is a part of the continual erosion of our rights, and in particular, the Second Amendment. Give me some time to advance this here. I'm trying to read it quickly because it's a fairly long letter. I'm expressing to you my deep concern regarding a bill proposed recently. I believe it is S-848, introduced on January the 9th, regarding an amendment of Section 1623.320 and 1623.430, South Carolina Code of Laws, and one or two additional laws within Title 16 and Title 23. The language used in 16.223, new one, is a bit confusing to me because it states, from what I read, firearm transfers must be preceded by a criminal background check by a licensed dealer. Okay. Sir, I believe this procedure has been in place already for many years whenever purchasing a firearm from a licensed dealer. Does the language in this new statute apply now to transfers between private individuals, to private individuals, such as a gift or a purchase of a firearm? Let me give you a quote you may have heard before. The right of the people to keep and bear arms shall not be infringed, end quote. Now that includes the right to acquire them as well, and to do so unimpeded, which means infringed. In other words, the state cannot complicate this process or force undue burdens on the people in order for them to exercise this right, or any other right for that matter. The sole purpose for such a scheme can only be for the benefit of the government to collect extra money and to increase a registry of firearms. And the history of other countries has demonstrated why a gun registry is dangerous for its citizenry. There was a legislation of this gun registry proposed about, I'd say, 5 or 6 years ago. Well, it was dead in the water. Statute 23-1231 gives police the authority to seize a firearm if it poses a threat to personal injury or to that of others. Sir, in this particular context, the firearm itself, cannot pose any sort of a threat of injury to anyone. Only another person can do that. If a threat of injury is present, then you seize the cause of the threat, which is the person. Firearms are inanimate objects and are not capable of doing anything without human manipulation. So, why does the statute specifically and exclusively pertain to firearms? Is a firearm the sole means of inflicting deadly injuries? And if the purpose is to protect someone from a threat of injury, well then why not authorize the police to also seize ball bats, swords, bricks, kitchen knives, ropes, scissors? I mean, the list is endless. Almost anything can be used to immediately inflict injury. Why are firearms singled out? I'd have to question the legality of government personnel seizing the personal property of anyone unless that property itself was somehow illegal, such as stolen, or it was used in the commission of a crime, or as a result of a civil forfeiture ruling. Any deprivation of a right, however short in duration, that has not already been sanctioned by the SCOTUS or the U.S. Supreme Court, such as a person having a history of violence, is presumed to be a violation of the Second Amendment and must be avoided. If decisions regarding the constitutionality of a gun regulation is not clear or it's ambiguous, then the rule of lenity must be applied. L-E-N-I-T, rule of lenity. In other words, the final decision must favor the law-abiding citizens, not the government. That's straight from SCOTUS. The old community safekeeping or caretaking policy, that's been around for a long time, but it's intended to allow the police to tow driverless cars or abandoned cars from the roadside in the attempt to protect the car from theft or vandalism and to help avoid other motorists from striking them. Now, trying to extend that to the seizure of firearms to protect the firearms or persons from them was struck down many years ago by the courts. Police simply cannot go into one's private residence and remove lawful property that is otherwise lawfully possessed under the guise of safekeeping or due to safety concerns. It's simple. If a person is threatening to harm others while possessing the means by which to execute that threat, then a crime has been committed. Arrest the person and take them to jail. If a person is threatening self-harm while the means to immediately carry out the threat is present, well, then he should be taken into emergency protective custody, which this state does allow, and then taken for a mental evaluation. No, this statute is yet again just one more way for the government to slowly and quietly disarm American citizens, nothing more. Now, this thing is long. This state already has a statute that prohibits the carrying of a firearm in sensitive places or gun-free zones. In the current proposal, an increase in penalty upon violation of this statute is put forth, all right? Increasing the penalty. Now, from a technical standpoint, it's probably unconstitutional to prohibit carrying firearms on the school property, post offices, social gatherings, malls, churches, synagogues, hospitals, and so forth, since these prohibitions do not meet the required Heller or Bruin standards of historical analogs review. In other words, if a gun control law today, or a very similar one, very similar to it, did not exist in writing on the books during the era of our founding and the time that the Bill of Rights was adopted, which is 1791, or that the reason for enacting that law today is different than it was then it is presumed that the present law is in violation of the Second Amendment. That is precisely the way the Supreme Court, U.S. Supreme Court, requires all lower court judges, whether federal or state, to go about making a decision on these matters. This is not dicta, it is a holding. Now, despite what many claim, our U.S. Constitution is not a living, breathing document. It's not a living document that's intended to change with time, change over time, with societal changes. Instead, the Constitution is intended to be followed and interpreted from an originalist perspective. It is to be understood as it was originally written and interpreted today, just like it was interpreted at the time it was written or in that generation. That's why judges are required to look for those historically traditional analogs or comparisons of gun regulations in the time frame of our founding era, and not in the mid-1800s or later. During the time our Bill of Rights was adopted, there was no such prohibition on carrying a firearm in school, a church, a park, social gathering, post offices, and so forth. Since there is no historical tradition of banning firearms in these locations back then, a 21st century law to ban guns in these places cannot survive constitutional scrutiny. And yes, this country did experience mass killings and violence back in the late 1700s, and with regularity, I might add. History shows that, and I can provide the documentation of those accounts. So society hasn't really changed much in that regard. The authors of our Constitution saw this. They saw this violence and mass killings. What did they do about it? Well, they certainly didn't enact gun restriction laws. They knew even back then that gun laws wouldn't solve the issue, and they still won't solve it today. If laws really did work, then the law prohibiting murder would work. Well, does it work? Obviously not. So, why think that stricter gun laws will work? Instead, our founders encouraged citizens to carry arms for protection by adding the Second Amendment to the Bill of Rights. So our shooting and killing rampages of today is really nothing new. It's not a phenomenon. It's been in our society for over 250 years. Now, there are more of them these days, but that's not due to a lack of gun control. It's only because our population has exploded since the 1700s, and our current generation lacks any coping skills or self-control. At any rate, the SCOTUS, in the Bruin case, has identified only 3 sensitive places that such prohibitions or gun zones may be, gun-free zones may be accepted, so far that is. And those are courthouses, legislative chambers, and polling stations or voting stations. In the Heller case, the SCOTUS did make reference to possible prohibitions of carry onto government property. However, this is in dicta only, so it's not binding. And, as most people know, unconstitutional laws cannot be enforced. In fact, it's a violation for any member of office who has sworn an oath to uphold, defend, and protect the Constitution to knowingly pass an unconstitutional measure. Now, if you're concerned with school shooting rampages, and we all should be, then the answer is not to reduce the Second Amendment rights of citizens, which does nothing to mitigate those shootings, but instead, the answer is to provide armed and trained security personnel on the premises. I've said this in another video. In addition, you should add those trained security personnel in addition to any school resource officers assigned to that school. In short, the proper response is to harden our schools, not to clamp down on gun rights. Do you know why the simple solution hasn't been done yet? It hasn't been implemented? Because it takes money. It's less expensive to pass some kind of feel-good, useless legislation instead. Are you concerned with mass shootings? Outside of schools, like a mall or something? Well, me too. But again, the solution to the problem is not more gun control laws or tighter restrictions on gun owners. Instead, the solution is to make it easier for nonviolent, law-abiding citizens to carry arms to better protect themselves and others, and to focus much more on recognizing and treating mental illness. But again, that would cost the state some money, and that's just out of the question. It's easier just to pass legislation restricting law-abiding gun owners. The government has no legal authority or right to continuously add more and more restrictions to our natural rights, especially those rights that are protected by the U.S. Constitution and spelled out in the Bill of Rights. Every state, New York, California, Hawaii, all of them must abide by the U.S. Constitution and the Bill of Rights. Lower courts, including individual state supreme courts, cannot overrule nor contravene any part of the Bill of Rights laid forth in the U.S. Constitution. They don't seem to be able to understand that. A state constitution may only increase or add to the existing rights of citizens. They cannot reduce or restrict their rights that are already enshrined within the U.S. Constitution, nor can any legislation. I'm sorry, but the legislators and judges, whether federal or state, don't get to do just whatever they feel like doing with our rights. When legislators are trying to draft a new gun regulation, or a court tries to determine if a gun regulation is constitutional or not, the trite "in the interest of public safety" excuse cannot be a contributing factor in that decision. To do so is introducing the old interest balancing scheme to that decision-making process, and the SCOTUS has ruled since the Heller decision, and several times after that, that this is not allowed. It emphasized that in the Bruin decision. Government cannot force Americans to forfeit any portion of their natural constitutionally protected rights in the interest of public safety or in the best interest of the public, nor can any legislator on behalf of the citizens negotiate away any portion of our rights. The safety of a free citizen in this country is solely the responsibility of the citizen himself, not laws. In fact, even police are not legally obligated or required to protect a citizen from other violent individuals. Most will do so, but they're not legally required to. And states continue to strip away our rights to adequately protect ourselves. It just astounds me. Gun control laws serve only as feel-good measures and political posturing to appease their voter base, and they do nothing to control crime or deaths in America. That's been proven time and time again for well over a century now. Our founding fathers relied heavily on the writings of Cesar Beccaria when they were writing the Constitution and the Bill of Rights. Here's just one quote from one of his famous books entitled On Crime and Punishment from 1764. 1764. And I'm quoting, "Laws against the possession of weapons only disarm those who have no intention of committing a crime. Can it be supposed that those who have the courage to violate the most sacred laws of humanity will respect the less important and arbitrary ones? Such laws only make things worse for the assaulted and better for the assailants. They serve to encourage rather than to prevent homicides, for an unarmed man may be attacked with greater confidence than an armed man." End quote. Sir, have we learned nothing in the last 250 years about firearms and crime? Firearms are not the problem. Violent people are the problem. Mentally unbalanced people are the problem. For years now, we've been watching government reduce our rights little by little, and no other right has been under this assault more than our Second Amendment. Once that goes, the rest will quickly follow. Basically, this proposed bill is just another gun control bill. And based on what? Where is the evidence to show that any of it will actually have a positive impact? I can only conclude that re-election time for some legislative members must be drawing near. The great state of South Carolina certainly doesn't need any more gun control laws or regulations in any form. In fact, our statutory laws relating to firearms needs to be reviewed and revised, and several should be rescinded in order to bring them up to U.S. constitutional standards, as many of our current statutes are an obvious violation of the U.S. Constitution. Simply using the old cut and paste method from the federal statutes is a waste of resources, since many of those statutes are also unconstitutional. Perhaps this is what our state legislators should be working on, as opposed to the never-ending endeavor to pass more restrictions upon our rights. Government, both federal and state, have a duty to protect our rights and the U.S. Constitution, not to wreck it, negotiate with it, constantly add restraints on it, or to otherwise molest it. All right, gentlemen, thank you for your time and attention, and thank you for the hard work that you put in for the citizens of our beautiful state. I am, of course, receptive to any communications from your office. Sincerely, my name, address, phone number, email, so forth. Okay, so that's the letter I intend to send to my two senators. I don't normally do things like this, but I just gotta, I don't know what else to do, you know. So if you can think of anything else, or point anything else out, or tell me what you think about it, I would greatly appreciate it, man. I'd like to have some input. And we'll get the next video. We'll get right back to guns. We're going to do a revolver series coming up next. So stay tuned for that. Be looking for that. All right. Well, fellas, thanks for putting up with this. I know it was boring. It's just a bunch of commentary, a bunch of yapping. But I just wanted you to know where I stood on this issue. Okay, because I don't mention much of it. All right. But, well, thanks for watching, fellas, and I'll see you next time right here on Shooting It Straight. Ciao.